The decision from Maine Secretary of State to remove Donald Trump from the Republican primary ballot is drawing harsh criticism and calls for an appeal. In statements to the Portland Press-Herald, the GOP leader in the Maine House called it a sham decision and warned it will not stand legal scrutiny. The state's Republican Senate leader says the decision undermines democracy and Maine voters deserve a primary process that allows for each party to decide its own candidates. The Maine GOP has said it will appeal that decision. Here's what the party chairman told CNN last night.
She has kicked a serious hornet's nest. I've heard just in the last couple of hours from so many independents, Democrats and Republicans alike. This isn't about Donald Trump. This is about our constitutional rights and the ability of the American people to elect into leadership the people that they choose.
And Maine Secretary of State Shenna Bellows joins us now. Good to have you with us this morning. I'm sure you had already seen and heard much of that criticism and more. How do you respond this morning?
Good morning. Thank you for having me. I think it's really important that people understand the process. As a general matter, states have the power to control their own ballots and in fact do under the Constitution. And Maine law specifically delegates to me as Secretary of State a requirement to review the qualifications for any candidate running for office. So for example, last week, the Superior Court found that my decision to bar Mr. Chris Christie from Maine's presidential primary ballot due to lack of signatures was lawful and correct. So my job, I qualify Mr. Trump for the ballot, and under Maine law, any registered voter can bring a challenge to that qualification. In this case, there were 3 challenges, and I was required by law to hold a hearing, an administrative hearing, to review the evidence, hear testimony. Both sides were represented by counsel. Mr. Trump was represented by an attorney, and then I'm required to issue a decision. That's my obligation under the oath I swore to the Constitution.
In terms of the criticism that your decision takes away the right for voters to have their voice heard, do you believe that's a valid concern?
Again, my first and foremost obligation is my oath to uphold the Constitution and the rule of law. Now, different states are different. For example, our neighboring New Hampshire, there are more than a dozen candidates on the Democratic presidential ballot, but Mr. Joseph Biden is not on the Democratic presidential primary ballot in New Hampshire, and there are more than a dozen Republican candidates. In Maine, there are 2 candidates on the Democratic presidential primary ballot and less than a dozen Republican presidential candidates. So every state is different. My obligation and duty, my sole consideration, is my oath to uphold the Constitution.
As you note in laying out there how things do work in Maine, given the amount of pushback you've seen, though, to doing your job as it's laid out in the state constitution, do you anticipate there could be a legislative challenge in the future to the duties of the Secretary of State in Maine?
So again, with the process, this decision now goes to the Superior Court and then can go to the Maine
But I mean
Supreme Judicial
specifically
Court
with your role, not in the way that this lays out Maine state law, but given the pushback that you're hearing, including from folks in your own state who know what your role is and what the state constitution of Maine lays it out to be in the state, do you anticipate that there could be some sort of a legislative challenge to that role or even to the state constitution?
So the legislature can always change the laws. I would be surprised if they directed me to stop enforcing qualifications for office. Some have suggested, for example, that I can't enforce age or residency or citizenship qualifications or the 22nd Amendment. I don't think that I'm permitted to put an 18-year-old on the ballot or a non-citizen on the ballot. My job is to look at the qualifications, and if those qualifications are challenged, to make a determination, but there's also a court process. The legislature, if they change that, I will absolutely adhere and follow the law.
In your decision, you argue that Donald Trump engaged in insurrection. You did hold a public hearing ahead of the decision. It's interesting to note, Democratic Congressman from Maine, Jared Golden, said in a statement in response to this decision, quote, until he's actually found guilty of the crime of insurrection, he should be allowed on the ballot. Did that consideration weigh on your decision or give you any pause?
I reviewed Section 3 of the 14th Amendment very carefully and determined that Section 3 of the 14th Amendment does not say conviction, it says engage. And let's go back and keep in mind that the events of January 6, 2021 were unprecedented and tragic. This was an attack not only on the Capitol and the government officials, the former vice president, members of Congress, but an attack on the rule of law. And the weight of evidence that I reviewed indicated that it was, in fact, an insurrection, and Mr. Trump engaged in that insurrection under Section 3 of the 14th Amendment.
We are waiting to see if the Supreme Court will, in fact, take up this Colorado case. I know you mentioned the Colorado case in your decision. When you look at where things stand, there is a question, our own senior legal analyst bringing this up. He doesn't believe that if the Supreme Court takes this up, that they will, in fact, rule on what engaging in an insurrection means, whether there needs to be criminality with it. If they do not, are you concerned about the fallout?
I will always implement what the court decides. And this type of proceeding is not unusual as part of my duties in Maine under Maine election law. In 2022, for example, I held a similar hearing on the qualifications of a district attorney candidate, found him unqualified. That was appealed. The court upheld my ruling. I mentioned Mr. Chris Christie just last week, a Superior Court finding that I had made the right decision in barring him from the ballot under Maine law. But I will always uphold what the court does, and it's part of the job of being Secretary of State. Should the U.S. Supreme Court rule that Mr. Trump be on the ballot, I will in fact place him on the ballot. It's part of why I suspended the effect of my decision until the courts can act. So no ballots are being printed until that Superior Court decision or Supreme Court decision might come down, although we're looking at a very tight time frame.
I was just going to say it is a very tight timeline. Yes or no, do you think this can get done in time?
I certainly hope so.
Okay. Shanna Bellis, appreciate your time this morning. Thank you.